Justice is one of those words that you'd think would be written 15 different times in the Constitution, but it actually only appears 3 times. And in the sense of justice as a concept, it only appears twice. And one of those, of course, is in the preamble. The preamble is very important because it sets out the basic tone, the basic purposes for which we have a Constitution. So it's very important that one of the main reasons we have a Constitution is to establish justice. Law enforcement is at the tip of that particular spear. We have a whole criminal justice system, a system that you're familiar with, but you're the first part of it. You're the thin blue line, if you will, that stands out there and stands between society and all the people who would do us harm, at least the people within our own society who would do us harm. And so, once again, as a law enforcement officer, you're directly fulfilling one of the basic purposes of the Constitution.
I think defining justice is a bit like defining due process, right? Or defining probable cause. It's one of those things we'll be working at for years. But I think for prosecutors, justice is fairness. It is, I want to say equity, but that's almost synonymous to fairness. In the context of the criminal justice system, justice is a response or a reaction to some sort of stimulus or stimulant that tries to correct or level or undo a wrong in a way that is consistent, fair, predictable, and neutral with regard to all sorts of suspect criteria.
Equal justice under law is essential to our notion of the rule of law. That is to say, one of the animating features of our criminal law, for example, is that individuals who have engaged in similar acts are prosecuted and are treated and are sentenced fairly. And if they are not, the Equal Protection Clause gives people, aggrieved people, a vehicle to challenge the conviction on the basis that they were not treated equally. Now, this does not necessarily mean that they did not engage in a substantive violation, but it simply means that you can't just go and take all black people, for example, and prosecute them for a crime. You can't just prosecute only women for a specific crime, but rather the law has to be even-handed, and the Constitution gives us a vehicle to challenge anything that is not even-handed.
The Equal Protection Clause of the 14th Amendment was revolutionary. It's the first time that the Constitution contains any variant on the word equality. In fact, it was such an enormous shift in our constitutional history that there are some people who call the 14th Amendment and its companion amendments, the 13th, which abolished slavery, and the 15th, which was voting rights for African American men, they call those 3 amendments the Second American Founding. That's how revolutionary it was. And so equal protection impacts many, many areas of constitutional law, or many different circumstances, many different cases. Its primary impact in the context of criminal law has to do with profiling and also with jury selection. Now, profiling is something that, on the one hand, can be a very effective tool for law enforcement. I mean, not everybody is going to commit every crime, and people who commit certain crimes might tend to share certain characteristics. And in fact, there are even people who are called profilers who go out and try to figure out what a criminal might look like or what his or her attributes might be. So it's a law enforcement tool, and it's a legitimate law enforcement tool. But what happens when you start profiling on the basis of something like gender, or when you start profiling on the basis of race or ethnicity? Is this any longer a legitimate tool, or is it merely prejudice and bigotry and stereotyping in ways that the Constitution no longer allows the government to do?
It's very important for there to be data about racial profiling and other problems. And so that's why in many places police departments are required to file reports for every stop they make, whether it's a traffic stop or an encounter on the street, where they detail the race of the person and why they stopped them. And that allows for the police department to analyze that data and see whether there's a problem in the terms of their in terms of their enforcing. And as those data become publicly available, it allows the community to agitate around such things. And it leads to law reform. It's led to some sentencing reform with regard to the disparity between crack cocaine and other sorts of cocaine. And that's a very interesting case because per capita, white people are more likely to use crack cocaine than black people in this country. But black people are much more likely to be arrested for it, and the penalties for crack cocaine are much harsher than for other forms of cocaine. So you have this strange disparity in enforcement, and those kinds of disparities can be revealed through statistics and through data, and then can be dealt with. It's very difficult to deal with those kinds of things in court, again, because there's no case that someone can bring that they were the victim of something. If they violated the law, they violated the law, and they can't use the fact that they're in a statistically disfavored group as a defense. But the community itself and the police departments can be more sensitive to that. And I think that's important because much of the agitation that you see about police practices has to do with this unequal policing techniques. And again, you're not going to be able to deal with that in court. You have to deal with that at the governmental level and at the police department level. The concept of equal justice under the law is very important in our system on a variety of different levels. The first thing is that all people in the law enforcement community should be confident that they are applying the law equally across different lines, whether it's race lines, gender lines, community lines, whether they're enforcing the law the same in the cities as they are in the suburbs, whether rich people are subject to the same laws that poor people are subject to. Sort of the whole idea of equal justice under the law, which is really a fundamental principle in our legal system, is that you're treated based on what you do, not based on who you are. That's the basic understanding. They say the law doesn't have regard to persons. And what they mean by that is that it's not who you are, it's what you've done, what your conduct is, how you deserve to be treated. So as a matter of sort of day-to-day law enforcement, any sort of favoritism that's played, any sort of discriminatory enforcement coming down harder on one community than on another, it really violates one of the basic ideals of our legal system. At a sort of a more abstract, higher level, it's really the whole ideal of a system of rule of law. That is, the whole idea of rule of law is that the law is applied impartially to everybody, regardless of their station in life, regardless of their status. You have this sort of metaphor of blind justice. And blind justice doesn't mean that that justice doesn't know what's going on. It's only blind to certain things. It's not blind to the facts of what people have done. It's not blind to the facts of what damage they may have done to society. But it's blind to factors that we think should be considered irrelevant in our society, which has to do with things like race, religion, gender, national origin, some people's sexual orientation or sexual identity. Those are the kinds of considerations that should not come into play in either day-to-day law enforcement or in the formulation of policy.